Next, the court calls number 1, Nissen versus Pierce County. You may go wherever you would like to go.
There might be a discussion about how to come up.
We'll wait for Mr. Parker. Do you want to approach Mr. Carter?
Good morning, Your Honor. Good morning. A little bit cold, so.
Sorry to hear that. We can start with introductions.
I'm Mike Carter here representing Pierce County.
Joan Mell representing Nissen.
So I have fewer questions than I thought I would. I will ask Ms. Mell what she believes would be appropriate for additional actions or input at this case. The reason why I have fewer questions than I thought I would at this point is because your briefing on the sufficiency of the supplemental affidavit was so voluminous in a helpful way that I find it difficult to believe that there is additional work to be done that would be beneficial for the court before ruling on the nature of the text messages at issue, and I am otherwise inclined to determine that I could rule on the nature of those text messages this morning. But I am open to feedback from you about what you think should be appropriately done instead.
Your Honor, it's Glenda Nissen's position that those text messages are public records and they should be immediately unsealed. And I would defer to the court as to the necessity for further briefing. I would just take exception to keep a clean record for appeal that it is Nissen's position that having the text messages would certainly be consistent with her rights to discovery to sufficiently and adequately argue that they are public records. I think that what we have shows that many are, so I don't want to waive that right, but still I think that a requester has the right to see what the record is in order to argue it's a public record.
Understood. And do you have anything else to add in this regard, Mr. Tardif?
Yeah, to the particular points the counsel raised?
To any sort of thing you would like to say before I'd be inclined to rule on the nature of these text messages this morning.
Well, Your Honor, your order, you asked for two things. One, you said that you'd like the counsel to speak to the steps.
I did not. I'm reconsidering that at this point.
Well, you are. Okay. The second was more or less on the merits. You asked what the position was on the merits of the message. So I was prepared to speak to both of those things, and I think it would be appropriate if I do briefly speak to both of those things.
You have my permission to do so.
First of all, as far as the steps, I would actually suggest, and I actually told this to Ms. Mell yesterday when I talked to her, I think the first step is you need to take one step backwards, because the county's position remains that the in-camera procedure doesn't apply in this circumstance, that is a procedure that's in the statute for the consideration of exemptions for public records, whereas this is a constitutional privacy interest involved for these records, and that really isn't something that was contemplated by that statute. I'm not even sure that the law developed in Washington on those privacy issues under the state constitution at the time Initiative 276 was enacted about 50 years ago. Second, the court had decided the recent Vermillion case out of that Division 2, I believe, is kind of controlling that issue. For reasons stated in the memo we filed with the court, the county doesn't believe that's the case. They believe that situation there was analogous to the exemption situation that I just mentioned. As far as the next step, we believe, and it sounds like the court's prepared to make it, although I'm not sure if it's on the basis I'm going to suggest, we believe, the county believes that the next step would be for the court to consider whether under the affidavits filed by the prosecutor pursuant to the procedure set out in the Nissen 1 Supreme Court case, whether or not the records are public or private. The court indicated in its order in December, I believe, that if the court thought that it didn't have enough information, therefore, as to whether or not the record was public or private, therefore, the impression I got was the court was inclined to rule then it was public because it didn't have enough information. But the county doesn't believe that the Supreme Court decision gives that option.
That was the impression. It was not my intention that would be the court. If there wasn't enough information, I would want it an in-camera review, not that it would be automatically deemed public.
Okay. I wasn't sure about that, Your Honor, so thank you for clarifying. In any event, I think the court's decision has to be based on the affidavits filed, because that's the procedure the Supreme Court set out, whether the record is public or private. Now, I'd point out that if the court feels there isn't sufficient information there to make that decision, I think the proper thing is what the court did the first time around this matter, which is to say, I don't think there's enough information, and give the county a chance to present what the court thinks it needs to make the decision. And so, if there is some deficiency in the court's view in the affidavit, then the court should specify what additional information the court needs to make the public versus private decision. And so I would suggest that would be the next step if there's still some concern that there's not information in the affidavit from which the court can not accurately, but properly make its decision on public versus private. I would again point out that basically the Supreme Court in Nissen 1, they adopted what we loosely call the federal procedure. There is quite a bit of federal law in these points, and I would again refer the court to the federal cases. I think many of them are actually cited in the Nissen opinion, and I think I've cited others in the briefing I've done for the court. There is a lot of federal precedent on this procedure and how it's handled, and it actually ended up that precedent, it really doesn't incorporate an in-camera review. It's simply done based on the information in the affidavits. That is essentially my comments on the steps, Your Honor. Your second part of your order was on the merits. You said that would be considered at this hearing. Now, on the merits, the court, I'll point out that based on the affidavits that were submitted, there were originally 147 text messages at issue, and the court, based on those affidavits, said 130 of them are not public, and there were 17 remaining in which there was some question. Those are the ones the court looked at in camera. I'll point out again that the county hasn't seen those, and of course they're provided just to the court, not the opposing counsel either. As far as what's said in the affidavits and those messages, there were basically three categories of messages. The one category had to do with the not to report a job applicant, because there never was a job applicant, but the issue, the joking about somebody that might apply for a job with the prosecutor's office, I believe. The second category was I think joking about comments on a news article in the newspaper made back and forth between the prosecutor and some other person. And so those are sort of the same issue, you are, and I think under the definition of public record that the Supreme Court adopted, something that must be used in the conduct of government, in other words, to make a government decision, to take a government action. I don't think those sorts of comments or messages fall within that definition of a document which is used by government. Now, the third category of information was simply there was an effort, somebody asked the prosecutor for a location of a document, I think a letter from a prior year, and asked if he knew where that was and if that could be located. And so basically the back and forth was over simply locating physically a document from a prior matter. And there is a lot of federal law in that says that those sorts of routine administrative inquiries simply about, setting a meeting or finding a document are not within the definition of public record. Those are kind of transactional things that don't really involve the operation of government, so to speak, except in a very ministerial sense. So on the merits, Your Honor, I don't think that, since apparently you're going to be speaking to that, that the messages which are described in the affidavits, the 17 messages, fall within the category of public as opposed to private records. I think, well, I'll also point out the federal law actually has quite a bit in it. The federal case is about, you know, we have the definition in the state that a public record is something which is, I think, what is it? Prepared, owned, used, or retained by the public agency. And the federal cases actually speak, they don't use quite the same definition, but it's very similar to federal law, and they more or less speak to that. So I think, again, the federal law is consistent with what our Supreme Court said in relying on the concerned ratepayers case versus PUD. So anyway, Your Honor, I think that's all I need to say at this point. Do you have any questions?
I do not.
Okay, thank you, Your Honor.
Ms. Bell, you may address any of these matters. I will indicate that you likely do not need to, but you may speak if you are so inclined at this point.
I have lots I could say, but I am going to defer to the court at this time.
Thank you. The court is prepared to rule on the nature of these text messages at this time. I will indicate at the outset that I am finding that most of them are public records. As to the July 30th, 2011 text message, there was one that remained for the court's consideration. That concerned a rumor about an attorney applying. Actually, let me take a step back for a moment. What is a public record? There are two very extreme positions that have been advocated by the different parties, as parties are allowed to do and are expected somewhat in civil litigation. On one side, we have the plaintiff contending through this litigation that, in essence, if a public employee created a document, even in this context of private cell phones, that is a public record. And that is not the definition of a public record. On the other hand, we have the county almost singularly focusing on the used part of the Public Records Act in a very narrow definitional sense, to the exclusion of how the Supreme Court has used the term used, as well as the other ways in which a record may be a public record. I'm going to quote from the Supreme Court's opinion in Nissen 1 with respect to this issue. When acting within the scope of his employment, Lindquist prepares outgoing text messages by putting them into written form and sending them. Similarly, he used incoming text messages when he reviewed and replied to them while within the scope of employment. That is a very broad standard that applies in this context. While there are other definitions of used that refers to a nexus of decision making, I believe a strict following of the most strict interpretation of that expression is not consistent with the spirit or the proper construction of the Public Records Act. It is not such that a record must be part of a decision file, so to speak, before government conduct is engaged in for an agency to be considered using a record. As the Supreme Court indicated by noting that Lindquist used text messages by reviewing and replying to them within the scope of his employment. That is consistent with the common understanding of use under the Public Records Act, and that is the standard the court is using in this case. Additionally, the court noted that Lindquist prepared outgoing text messages within the scope of his employment. That doesn't require any sort of decisional nexus under the use prong. That's simply preparing a record as a public employee relating to governmental conduct. That also would apply if Lindquist had a record that was sent from a public employee to his phone in the context of that other employee's employment. That is then a public record because a public employee, doesn't have to be Lindquist, prepared it. And so using those standards, turning to these specific text messages, the July 30th, 2012 50 text message concerns the rumor that someone applied to the or was going to apply to the prosecutor's office. Whether something is a rumor or not a rumor, it concerns employment applications in the context of the prosecutor's office. It relates to the governmental conduct in that respect, the employment practices of the prosecutor's office. It was also prepared by a county employee in sending this to Mr. Lindquist. It does not need to have been used in any very strict sense, but one could also conclude that it was used by the prosecutor being made aware of this fact. The fact that there are possibilities that things might occur are relevant to governmental conduct, even if they do not come to pass. Whether or not something comes to pass later, after a record is created, cannot determine the nature of a public record. It is determined at the time the record is made. Accordingly, that text message is a public record. Turning next to the August 1st text messages, there were 3 that that the court had not yet ruled upon. The court finds that all 3 of those are public records. Those relate to the rumor that the individual identified in the prior text message was going to be applying to the prosecutor's office, and relates to comments about that person. That is, while perhaps humorous in nature, is relaying information about a potential applicant, and thus it was prepared by a public employee sharing information that could be of possible use to a public agency. Accordingly, those are also public records. Turning next to August 3rd, there's a couple different types of records on this date. The court finds that the first 3 are public records. They relate to the posting of comments on an internet news story. And based on my in-camera review, it appears that these are linked to the text message that Judge Tabor ruled was a public record and was further communication regarding that directive in that other text message. Given that this relates to a public record that under collateral estoppel, these parties are bound by the determination that that was a public record on that prior date under Judge Tabor's ruling. These documents or records are also public records. The remaining text messages from that day, the last 4 on August 3rd, are not public records. While they are in some indirect sense also related to the messages I was just speaking about, they are general humorous comments about other comments on that online newspaper article, and thus it is simply an observation of actions that aren't related to governmental conduct. Those text messages are not public records. Next we have August 4th. The first 2 text messages of that day are public records. They are prepared by a public employee, although not Lindquist, and relate to governmental conduct. The court is unable to determine that the last 4 text messages of that day are public records in this case. And that addresses all of the outstanding text messages. Do the parties require any clarification regarding the court's ruling?
Your Honor, I do on one matter.
Mm-hmm.
And that is, was this ruling based on the court's review of the affidavits, or was it based in part on the in-camera review?
Both.
And if so, what parts?
It was both. Totality of the circumstances.
So you're ruling on all of the 17 were based on
both.
On both, okay.
Yeah, by necessity, based on the court's prior ruling that I could not rule without seeing the text messages as to these 17. As to all 17, I am ruling based on the affidavit and the in-camera review.
Go ahead. Go ahead. No, I'll defer to you.
The second would be in course, I'll have to, as the court's aware, I report to the Pierce County Council legislative body on this case because of the unusual circumstances. I will need to consult with the council.
I'm inclined to set a status conference at least 30 days out so that anything that
Okay.
needs to happen in the interim can be discussed.
And counsel for plaintiff made the request in her remarks that the court, upon ruling, immediately say that they're public and
I will address that
would-
at this point. Given the privacy and the constitutional concerns at stake, I am not going to rule that the documents be immediately unsealed and provided to Ms. Nissen. To do so would effectively deprive Mr. Lindquist of his due process rights, because once that bell is rung, it cannot be unrung by unsealing those documents. And so I am not going to be unsealing or directing that they be produced at this time.
And as far as entry of an order, because of the nature of the court's order saying this here, it wasn't clear what was going to happen, if we need an order or not.
I don't think Your Honor.
Oh, you brought, okay.
And so if the parties,
Well,
were you line editing that as we were going along?
I didn't line edit it, but the texts are there. I think we can just, each entry is there. I think we can just say on there which ones are and are not, and then whatever further ruling the court wants to include. I did say that they shall be disclosed.
I will hand this back, and I'm going to get to the next matter and allow the parties to confer about what the form of the order should be. And if
Okay.
you can't agree, I will resolve any of those disagreements before you leave today.
And
Your Honor, I would actually like a little different procedure if possible. I would like to get a consultation after with the council. I'm going to want to get a transcript of the court's remarks and then meet with them. And I would prefer allowing me to look at the transcript of the court's remarks before we actually enter an order, if that's an acceptable procedure of the court.
So I'm going to allow that, but I'm going to set I'm looking at the dates again. February 23rd. I'm going to set a status conference, and in this case, so we can determine next steps to allow any sort of interim action that might need to occur, and that will not be delayed based on any delay in terms of entering an order. In the interim, if the parties can agree to the form of an order to enter, they may submit it through ex parte procedures. If they cannot, it can be noted for presentation, and we can hash that out on the back end. Given the nature of this ruling, however, and given a request from a party and the nature of this ruling, I believe it is appropriate to allow time for the preparation for the form of this order.
Unfortunately, I think that February 23rd date.
Is that bad for everyone today?
It's bad for me. I'm way out of town, like 1,000 miles out of town by that day. I could have my partner, I'll be on Canada, I could have my partner, Mr. Fryman, to appear. It'd be probably better with me, because
March 2nd?
March 2nd would be acceptable.
Well, does that work for you, Ms. Mel?
Can I make a record with regard to the ruling? Glenda Nissen just takes exception to not immediately publishing the public records.
Understood.
I have a hearing at 9, but I can try to juggle that. It would be fine.
Let's do that then. March 2nd.
And one of my concerns is the unilateral submission of briefing without an opportunity to respond, and I didn't make an issue of it when the texts were submitted in camera. What's the court's expectations with regard to March 2nd, that they're, whatever people want to brief, they brief, or we're just going to come back and talk about next steps?
Candidly, this is to allow any opportunity for any interim discretionary appeal request that might happen.
Okay.
And if that does not happen at that point, then the documents are very likely to be unsealed at that point. And that is that.
Okay, thank you, Your Honor.
Anything else?
Nothing, Your Honor.
Great.
Appreciate your time and consideration.
Thank you. Have a good weekend.